Welcome to the Aspen Institute. We're delighted to have you here today, and I have a couple of questions leading up to our lunchtime roundtable on the health care reform litigation.
Right.
Is that letter a concession that time favors the administration in terms of implementation of provisions of the bill while the litigation is pending?
Well, that may be an ancillary fact, but what we really are trying to do is to create certainty and finality. I think no matter what side of the underlying healthcare debate you might be on, that everybody in America, businesses, families, healthcare providers, want to know, is the law going to be upheld or not? Let's get it done. And that's the purpose of the letter, is to say everybody knows the Supreme Court's going to make the final decision. There's no need to go through years of litigation, and intermediate courts maybe have different decisions. Let's have the expedited appeal under Rule 11, which can be done on issues of national importance, well, this clearly is, and get an answer, so that if it's not constitutional, we can avoid the expense. If it is constitutional, we can get on with implementation. That's the purpose of the letter, and I would certainly hope that Democrat governors, who we've sent the letter to as well, would also be willing to sign on.
What is your view of mass care? Do you see that as being a potential model for what could be done in Virginia if Virginia was left to its own devices to come up with a system of care?
Well, there's first a legal difference that's fundamental. One is that if state constitutions permit this kind of regulation and insurance mandates, then it's okay. Our fundamental problem, apart from the policy concerns, is that no matter how laudable the goal is, you can't violate the Constitution and the Commerce Clause to affect a policy. So it may be legal to do in Massachusetts, but not legal to do to have a nationwide mandate. Secondly, it's certainly probably not something I would favor in Virginia, these kinds of mandates. I think we ought to try something just the opposite, is a little bit more of the free market system, not have state or federal mandates in some of these areas, which generally end up driving up the cost of health care and driving up the cost of the bureaucracy. So we have actually formed a health care initiative. My Secretary of Health, Dr. Bill Hazel, has been meeting with all the stakeholders in Virginia for about 6-7 months to find out how can we best implement the federal health care initiative if we have to. And secondly, what are the other things that we can do in Virginia to look at cost, the cost of delivering services, care coordination and management, out of control Medicaid spending, the health care provider shortages, prevention. There are a number of other things that I think it can be done, Meryl, at a state-based level that will be helpful. But I don't particularly think the Massachusetts model is one we'd adopt in Virginia.
Okay. Are there portions of the Affordable Care Act that you do think are good ideas and that you would like to see continued?
Well, legally, let me answer legally in the policy. From a legal standpoint, the Florida court has essentially ruled that because the case is not severable and that they're all interconnected, that the entire act is unconstitutional. The Virginia judge only ruled that the individual mandate itself is unconstitutional and just struck that. The Justice Department has consistently conceded in their briefs that all of the insurance-related provisions essentially fall if the individual mandate is struck because they're so interconnected.
Right. I call that everybody into the pool, because everybody has to get into the insurance pool, is their theory, for it to work.
I think that's exactly right.
Right.
So, but first of all, the goal is noble, increasing access and reducing costs. Noble goal shared, I think, across the political spectrum. How you do it is the question, and who's got the authority to do it is also the issue. But I think extending the opportunity for kids up to 26 to stay on parents' policies, not a bad idea. Finding ways to eliminate the bars for pre-existing conditions, probably not a bad idea. In some cases, in some states, some sort of exchange might work. We're looking at doing that, and whether that would work in Virginia, regardless of what's going on at the federal level. It's not to say that the whole act is without merit. There's 3,300 pages. There ought to be something good in there, and we're trying to look at what those things are. But the fundamental question is, what do we have to do based on the federal law, and then what should we do based on what's good policy for Virginia?
Well, Governor, I'm going to leave the questions about the Commerce Clause and the Constitution to my colleague Jeff Rosen, who's going to question you during the panel. Thank you very much for your time.
Thanks, Meryl. Good. Oh, so you did get